This next question is going to presuppose you've been elected district judge. And the question is this: if you observed a party in your courtroom, a litigant, being poorly represented by an unprepared or ineffective lawyer, how would you handle that situation?
It's a tough question, Mr. Rising, because I remember being that green attorney that in front of Judge Nelson that really had no idea what he
would be good.
really had no idea what he was doing. In fact, I could see it like it was yesterday because the tongue lashing I got was worse than you could imagine. I wouldn't handle it in that way, but it certainly made an impression on me. I don't disagree with what Ms. Cart said, to be honest with you. I probably would have a conversation with both counsel and chambers, but more important to me would be why we were in the situation that we were in. I think that if there is some type of problem that was just preparation, I think that's something that can be corrected. If you're trying to get to the heart of the issue and perhaps someone has a substance problem or some type of activity that's not letting them perform at their peak ability, I think that's something that you have to address, and we as a legal community would have to address. So, you know, I think I would approach that perspective based on the one that I got when I was a young attorney. Thank you.
Thank you. Take you back out of the courtroom now. Go back. You're all back as lawyers again. I'd like you to describe the legal case in which you're most proud. Thinking back over your career, what case are you most proud of in terms of it sort of sticking out, so to speak, from the rest vis-a-vis the practice of law? Mr. Snodgrass?
Thank you. I had the opportunity to represent a family here in Burton who lost their son, and I'm very proud of the work I did on that case. But I think the case that I remember the most is a case that I had while working as representing DHS. In the unit division I work in currently, we represent Department of Human Services and child abuse and neglect cases, and I had a case involving the severe abuse of a 14-year-old who went to Southwestern Academy, and he in fact had been beaten so bad that his one retina had detached from his eye, and he was unable to see out of that eye. Turns out they took him to some specialists, and he had a condition that also meant that he might lose the other eye. So the parent was on notice of that and knew that she had to take him immediately if he started to see white spots in his eye. Well, he indicated to his mother one day that he had started to see the white spots, and she decided instead of picking him up and taking him to the hospital that she would go take her boyfriend back to Detroit where he resided, and unfortunately the young man lost sight of both of his eyes, and he could see some shapes, but he had to read books with the big letters in them. He came into court and he had his head on the table, and we were going to have trouble getting him to testify, which we needed to sever that relationship between his parent, and we tried to determine why it was that he was upset, and we figured out that it was because he didn't hate his mom and dad, but he looked strange. His eyes were white and they didn't look like anybody else's. We finally, I think through my efforts, got him to testify and ended up severing the relationship between his mother and the parents who had beaten him so badly and taken him to drug houses and such. And I'm very proud of that. We afterwards got him a big brother and big sister and got him on the right path. He's an A student now, by the way. So.
We're going to change gears again. You're going to be back sitting on the bench. You're elected. I'd like you to name one change that you would make in the 67th District Court bench, assuming that you were in that position. What change would you like to see made in the 67th District Court bench? And we'll start with Mr. Snodgrass.
Certainly, I mentioned my healthy respect for sitting judges, and I see Judge Hughes back there, who I have a great amount of respect for. And please, Judge Hughes, don't take this as any disrespect. I don't mean it that way, but I think Judge Hughes got sort of stuck with a way of doing things in terms of efficiency that has existed with smaller dockets, and we don't have the small dockets that we used to. And I know that Mr. LaChana has already mentioned it, and it's something that I intend on doing if I'm in that same position, is more streamline the courtroom in terms of how things flow. Being in the position that I've been in for the last 11 years, I've had the opportunity to meet and talk to victims and witnesses and police officers on a regular basis, and I think the one thing that they say on a more regular basis than I can even imagine is that they don't like to come here. They don't like to come down to the courthouse. And in fact, they certainly don't like to do it multiple times, which is what this current situation has got us in. I would hope to expand the opportunity to have felony exams in this court. It's kind of technical, but to more than just a few hours on one day. I would hope to expand that to more time. And I would hope to move around misdemeanor pretrials or state pretrials in order to have one subpoena, one visit concept. I would hope to try to speed up the process and more streamline it. That would be the thing.
All right, we're back out of our judicial roles again, and this question is a question which is many times in the public eye these days. And the question is this: do you believe that our judicial system adequately deters and penalizes frivolous litigation? If not, what reforms would you like to see?
I remember the case from law school that I think was used to illustrate this point the most, at least where I was. The situation was a thief was climbing across a roof and wanting to get into the house to steal goods, and ended up putting a leg through the roof and injuring his leg when he was on the roof to steal, and then turning around and suing the homeowner for having a bad roof and winning the suit. And I think that was the case that they used to sort of explain this sort of type of frivolous lawsuit. But I, in some sense, agree with Mr. LeChan in the sense that it's not frivolous to the person who broke the leg. Now, he happened to be a thief in that situation, which makes it a bit of a different case. But quite frankly, I, in some sense, disagree with what I've heard so far. I trust this bench, and I trust the bar in general. From the prosecutor's perspective, I turn away what would be termed as frivolous warrants on a daily basis. And I think we have that check in our office. And certainly in my civil, what really is quasi-criminal or civil practice in representing the Department of Human Services, we've, in my office, including myself, have decided to decline to represent them in circumstances where we didn't feel that the petition was sufficient to prove what point they were trying to make. So, to be quite honest, I think it's a lot more ballyhoo than really anything else. I trust this bar and this bench. In fact, I was trying a case in front of Judge Hughes once, and it was probably overcharged. And he, in fact, at the end of proofs, told me so, and he made the ruling that it was overcharged, and he reduced the charge. So I really have no problem. I think folks are doing what they're supposed to in our practice on the bench.
Thank you.